I want to now shift focus to the big story that we're tracking today. It's a major verdict by the Supreme Court of India, which in a way reaffirms the separation of powers between the judiciary and the executive. This was on the question of governors sitting on bills and not giving their assent or forwarding it to the president for consideration. The court today has ordered that it cannot impose any sort of timelines on governors because that would mean it would be infringing on the domain of the executive. But at the same time, the court also said that governors cannot withhold their assent indefinitely. Will the opposition now stop saying that the BJP government is basically using governors as their lackeys to stop those bills that they don't agree with politically? Let me first take you through what the court said. It's a significant order. It's a constitutional bench order. In a way, it corrects a previous order of the Supreme Court itself, which had imposed a deadline of 3 months on the governor and on the president for giving a decision on a bill that's been passed either by a state legislature or by the parliament. Answering the reference made by the President of India, Draupadi Murmu, under Article 143 of the Constitution, the Supreme Court held that the court cannot impose any kind of timelines for decisions to be made by the President or the Governor on granting assent to a bill. The court further held that the concept of courts declaring deemed assent to the bills if the timelines are breached is antithetical to the spirit of the Constitution and against the doctrine of the separation of powers. The court also observed if there is a prolonged or unexplained delay by which the governor frustrates the legislative process, then the court can exercise a limited power of judicial review to direct the governor to decide in a time-bound manner without observing anything on the merits of the bill.
Delivering an advisory opinion or verdict on a rare constitutional or in fact a rare constitutional site, which is in fact a presidential reference given out by in fact President of India Draupadi Murmu, giving out 14 questions of law with regards to the powers of governors and the President of India and timelines with regards to that. The Supreme Court today held in a 5-judges constitution bench headed by the Chief Justice of India, Justice B.R. Gawai, clearly going on to say that timelines for the governors and the president cannot be fixed because it goes against the separation of powers doctrine, which is in fact an important facet of the Constitution of India. Not only that, the topmost court of the country also stated that though the governors cannot be directed or given a particular timeline, but if at all there is in fact a prolonged delay in exercising of the options available under Article 200, 201, by the governor, then the courts can have a limited intervention per se as far as directing the governor to actually act on the bill is concerned. 3 options are available with the governor under Article 200 and 201. One is to give an assent to the bill that has been sent by the State Assembly. Second is to send the bill back to the Assembly with its comments. And third is to withhold the bill and send it to the President of India. In fact, the Supreme Court also went on to say that for every bill, there is no need for the President of India to actually send in and seek a legal opinion under Article 143(1) from the topmost court of the country, and only in circumstances which deem it appropriate should such a jurisdiction be exercised.
Now, this verdict is significant because it resolves a key federal dispute between the centre and the states. It affirms that neither the governor nor the president can be forced into judicial timelines or deemed assent for state bills, curbing the sweep of the 2024 Tamil Nadu ruling. It reasserts the separation of powers between the executive and the judiciary. The states that deemed assent after the court set a deadline effectively makes the judiciary perform the function of the executive, something that the Constitution does not permit. It also clarifies that Article 200 and the options before the governor essentially has only 3 choices. Number 1, give assent. Number 2, withhold and return the bill back to the legislature. Or 3, reserve for the president. An indefinite pocket veto is unconstitutional, is what the court has ordered today. It also safeguards the discretionary powers under Articles 200 and 201, which is generally beyond judicial scrutiny. It allows only limited judicial intervention. The courts may order the governor to decide within a reasonable period of time in case there is an unjustified delay without commenting on the merit of the bill or influencing the outcome.
So if any bill is passed by the cabinet, which means it has legitimacy from the people of Tamil Nadu, 8.4 crore people who have elected the government, in this case DMK government. Governor is nothing but an appointee. So how can an appointee who has no legitimacy from the people sit on a bill indefinitely?
All right, I want to go across for a quick face-off on this. Rohan Gupta of the BJP is joining us. Ashpreet Kadyal of the Congress is joining us. So, Ashpreet, the court basically saying in absolutely clear terms that it's not the court's job, it will be infringing on the executive's domain if the court were to set these kind of artificial deadlines or court-set deadlines for the governor or the president to decide on assent to a bill. So essentially what you've been arguing for, and when I mean you, I mean the Congress party, other opposition parties, state governments, you've been arguing for, a fixed deadline for governors to act on bills. The court has not bought that argument.
Well, number one, what the Honorable Supreme Court has said, we welcome that the governors cannot sit over bills indefinitely. They do not have unfettered powers, and they have three options: either to give assent, or to give it back to the Legislative Assembly, or to send it to the President. Now, the reason as to why this was important is because when you make a bill, a lot of time, energy, and resources go into that, of the government, of the bureaucrats, of the people. And there are times when it's very urgent for the welfare of the people, for the betterment of the people, and there's an urgency to it. So in that scenario, when the governors used to sit on it, the people used to suffer, the democracy used to suffer. And now that the Honorable Supreme Court has said that the constitutional courts can intervene, that it is open to judicial review, it is a welcome step, and we welcome this.
No, but Kashmir, the court has also said that this concept of deemed assent after a court-set deadline cannot happen. The court is not in concurrence with that because the court feels that would mean the judiciary is overstepping into the domain of the executive. The court has very clearly said that today.
That the court has said, our objective was, number one, to ensure that the bills are not put out to, just hang out dry. They used to keep on staying there for months and months, and the people used to keep on waiting. And some very important bills. And now, after this order, we'll be able to go to the courts and we'll be able to get a judicial review if in case there are going to be prolonged...
No, but my understanding, and I'll go to Rohan on this, my understanding is the court has said you can only approach the court once it's passed as an act. You cannot approach the court if it's still in the bill stage.
No, 1 second here. Now, that is what the Honorable Supreme Court has said, that if in case
Correct.
if there is a delay, and due to that delay, the legislative process is frustrated, in that scenario, judicial review is very much possible. And the Honorable Court can intervene.
Rohan Gupta, so see, basically the point that the opposition is stressing is that the governor has only three options. One, either give assent or withhold but return back to the state legislature. You cannot sit on a bill indefinitely, the court has said. You cannot have this indefinite pocket veto, which is unconstitutional.
Completely, Zaka. And I think it's a very insightful bill which brings clear-cut boundary of judiciary and the confusion which was created in Tamil Nadu where the High Court has passed order. This order clearly tells that boundaries, the timeline cannot be set by judiciary as far as governors are concerned. However, it really brought the concept of dialogue rather than just keeping the bill pending. That is also welcome. But at the end of the day, it is the responsibility of the state government also to ensure that what are the concerns of the governor that can be definitely discussed through dialogue and then can be resolved. So absolutely, this is a tight slap on opposition parties' demand for fixing the time limit as far as governors and president is concerned.
But the opposition has been claiming, look at all the states where the opposition is ruling. It's only in those states, Kerala, Tamil Nadu, Punjab, etc., where they are withholding the bills. They're withholding assent to the bill. In BJP ruled states, no governor is sitting on a bill.
See, we cannot generalize, right? You have to take the governor in confidence. And again, that's what Supreme Court has said. While they have said that we cannot decide the timeline, but definitely they have, clearly said, emphasized on the process of dialogue. If there is a gray area, definitely it has advised the government to engage in dialogue with governor. That is what is required in democracy.
So, Ashwin, the court has also said, and it safeguards the discretionary powers given to the governors under Articles 200 and 201, which is beyond judicial scrutiny. It only allows a limited judicial intervention where the courts may order the governor to decide within a reasonable period in case there is an unjustified delay without going into the merit of the bill per se.
Definitely, and that's exactly what we wanted. We did not want for the courts to get into the merits of the matter or of the bill. We wanted the honorable courts to have a say if in case the governors, like you said, Zaka, you very rightly pointed out that in the opposition ruled states, many a times it has been witnessed that the governors sit over the bills, and this does not seem to happen in BJP ruled states. So when that happens, we show a pattern, we show a history, we show it that unnecessarily there is a delay that is being caused, and we can go for a judicial review. It's been made crystal clear today. So it's a win for the democracy. It's a win for what we wanted. And all I'm saying here is that it's a matter between elected and selected. We believe in the elected.
The thing that the court has struck down today, Rohan, is this whole deemed assent concept. That is, if, according to the previous verdict, if a governor sat on a bill for an indefinite period of time, I think the period of time that the court opined was 3 months. If it sat on a bill for more than 3 months, then it is deemed assent because it's been passed by the legislature, it's been passed by majority. The governor cannot sit on on bills indefinitely. As I said before, he has only 3 options: either forward it to the president, return it back to the state legislature, and if it's returned back to him for a second time, then he or she has no choice but to give the assent. And the role of this pocket veto that the court has clearly said is unconstitutional. He cannot be a pocket veto.
That's what I'm saying, Zaka. It is a tight slap on opposition face, where court has clearly said that the timeline cannot be decided by the judiciary. That is what the opposition was telling. The order which was passed, which decided the timeline of 3 months and deemed assent, if it is not passed in 3 months, it is assent. So that is going into specific of the bill. Judiciary cannot cross that line of just being advisory rather than going into merits of it. And that's what's the win of the constitution here. That it really brought the clarity. Absolutely, it cannot be put indefinitely. And that's why the final court comment says that you should engage in the dialogue. That is the advice to the state government. If governor has certain objections and you don't take that seriously, obviously governor has to use his power under the constitution. So it is a responsibility of now the state government to ensure that whatever apprehensions the governor have, there has to be a dialogue. What is happening in opposition state? They are, completely adamant. Whenever the bill goes to governor, it is brought back again for the government to discuss. They will not discuss, or they will not put focus on the merits of